the jury is not present, we needed to take up the Bosco matter.
I know, Your Honor. I'm just wondering whether or not there's two housekeeping matters with regard to the last witness that I can take up before you get into
Sure.
the Bosco matter. Thank you.
Yeah, before we do that, Your Honor, Ms. Clark probably left the courtroom.
Okay, well, summon her back.
Thank you. I'll wait until she comes back.
All right. All right, I understand we have counsel for Mr. Bosco, Ms. Esinski, and Mr. Sullivan, correct?
That's correct, Your Honor.
All right, good afternoon. Counsel, would you state and spell your names for the record, please?
Yes, Your Honor. Last name is Sullivan, S-U-L-L-I-V-A-N.
Your Honor, Halina Esinski. First name is spelled H-A-L-I-N-A. Last name O-S-I-N-S-K-I.
All right, good afternoon, counsel. Thank you for making yourselves available on such short notice.
Good afternoon, Your Honor. At this time, we've just been retained, and we have not even had a chance to speak with our client, Your Honor, because he has been in the courtroom. We would like a little bit of
Take
time.
him out of the courtroom.
We would like a little bit of time, because the Shield Law is involved in this matter. We'd like a little bit of time to be able to brief it and then to have a hearing on the matter. It's at the court's disposition as to when you would like to hear this matter, but can we put it over to another day as opposed to this afternoon?
Sure. How much time do you think you need?
Well, we would like to submit something in writing by tomorrow and maybe be heard after the court session on Wednesday afternoon. Would that fit in with your schedule,
See,
Your
I think
Honor?
we have the continuation. Would you be available tomorrow at 4 or 4:15?
We could, Your Honor, yes.
That'd be fine.
Okay. Because, all right. And Ms. Osinski, Mr. Sullivan, have you had the opportunity to confer with Mr. Shapiro regarding the issues that they seek to raise with your client?
Just very briefly, Your Honor, we've just...
All right,
very
then I'm going to
briefly.
direct counsel as soon as we break on this issue then to confer, to meet and confer and see if there's any narrowing down that we can do of the issues involved.
Thank you, Your Honor.
All right, is there anything else that we can take up as to the Bosco issue? All right, I've been provided with, counsel, do you have a copy of the article that's referred to?
Your Honor, we don't have a copy of the article or a copy of the subpoena. We have nothing.
Okay.
I gave a copy to Mr. Morrell, so I'll arrange for a copy.
Okay.
All right, I think my staff has a copy of the article in question.
Thank you, Your Honor.
All right.
Your Honor, while we're waiting for Ms. Clark, I think you have to resolve this scheduling problem now with tomorrow. I'm assuming that Professor McDonald will certainly be finished within an hour tomorrow morning. It was our intention to call, if not Tracy Savage as the next witness, certainly Michelle Kessler. However, Michelle Kessler, at least tomorrow, we'd like to resolve the 402 issue as it applies to Tracy Savage. As was pointed out to you by my colleague, Dean Uelmen, we wish to add to the hopper, if you will, for your thinking about the various factors, Michelle Kessler's outside the presence of the jury testimony on that limited issue.
Okay.
There was some mention that she has an appointment, or she has, I think, a funeral or something in the afternoon. So perhaps we could do at least the outside the presence of the jury portion of her testimony earlier tomorrow. But we do not have another, and we can play the Paratus tape, but you know that doesn't take up much time. But after that, our next witness is Dr. Gerdes, and we're not ready yet with Dr. Gerdes. We'll be ready with him by Wednesday morning, but we are not ready. We were planning on having these other witnesses Monday and Tuesday.
I'm just thinking, I can't believe, although I've been wrong before, that Mr. McDonald will take up the full morning session.
No, I think you're right, he won't. Ms. Clark represented that she only has a few minutes, I believe.
All right.
Your Honor, is the court aware that Michelle Kessler is not going to be available until probably late tomorrow afternoon? She was attending a funeral.
No, I'm aware she has a funeral obligation in the afternoon. What's her status in the morning?
Well, I think she's leaving for the funeral and will not be available after 11, and then will probably be available again after 4? What's your best estimate?
Since her testimony, at least to make out this offer, should not take more than 20 minutes,
How about if we start with her at 9, do that out of the presence and
Right.
bring the jury down? That sounds like the best way to do it.
right,
Well, Your Honor, the other possibility would be to require counsel to make an offer of proof as to what she's going to say, or they think she's going to say outside the presence of the jury that would be relevant to the issue as to the...
I think we've already gone over that, though. If you recollect, Mr. Goldberg, this morning, we were just sort of thinking out loud that Ms. Kessler could testify to any inquiry that was made of her, any knowledge that she has, or any action that she took regarding leaks. I mean, there are things that as the then acting head of the laboratory and now the head of the laboratory that she can speak to with regards to this issue.
Well,
So I'm convinced that there's enough to at least ask her some foundational questions with regards to these issues.
What Your Honor might not be aware of is that counsel did speak to Ms. Kessler at length, so they know specifically what she would say and the extent of her knowledge on many of these issues, which is
Well,
very
that's not
limited.
the point, though, Count. The point is that for me to go further on the Tracy Savage issue, they want to offer more evidence with regards to the materiality of the issues concerned. And maybe I misunderstood the comments of other counsel, but I consider this to be a very serious and very sophisticated issue. So there.
we'll do that at 9 then?
So why don't we take that up at 9? I assume, Mr. Uelmen, we're talking about a relatively brief direct examination, 20 minutes or so.
Yes, actually, Mr. Neufeld will conduct it, and it should take no more than 20 minutes.
And I have to do that, because if it's any longer, I have to deal with Professor McDonald, who's already been out here 3 times, and I assure the court that that's what we're talking about.
Okay.
Right.
All right.
Um,
All right, so tomorrow we'll take up Michelle Kessler first. We'll finish with Mr. McDonald. We'll play the Thano Paratus tape. And then, if we haven't resolved the Tracy Savage issue yet, then we may run out of witnesses. But even if we have the Tracy Savage issue, well, I don't know how long that could take.
There is one other issue that Your Honor may be able to resolve today. In addition to the tape, we would like to present the Thano Paratus grand jury testimony. I don't know if that has been resolved yet.
No, that hasn't been offered formally to me. It's been mentioned, but nobody has cited, nobody has argued the admissibility or non-admissibility of the grand jury.
We can do that now.
All right.
Well,
No, we need to discuss one other matter. All right, let's finish Mr. Neufeld's. Do you need to go?
okay, then let's take care of this now then.
All right.
There are 2 items. One is, in front of the jury, Ms. Clark erroneously represented to this jury that the prosecution did not receive the notes of Professor McDonald from the April 2nd visit, an inspection of the socks. That was just flat out wrong. I'm not going to attribute a motive. I have no idea what was in her mind, but it's flat out incorrect. I have given the court a signed copy of an acknowledgement of receipt of discovery signed by Mr. Darden on July 17, 1995, in which, if you see, item number 3 on that sheet are the laboratory worksheets of Herbert McDonald dated 4/2/95. In fact, when the report was typed by a member of Mr. Cochran's office, she mistakenly said there were 2 pages of notes. When Mr. Darden looked at the notes, he observed that there were 3, and so he crossed out the 2 and he wrote in the 3. The 3 pages of notes were inspected again by Ms. Clark this afternoon. She has really, I think it's just completely inappropriately tried to prejudice Mr. Simpson by suggesting to this jury that the defense did something tricky in not turning over those notes. The notes were turned over. There's no question they were turned over. If by chance Mr. Darden didn't get them to Ms. Clark, or Ms. Clark may have misplaced them, I have no idea whether some inadvertent mishap occurred. But the bottom line is those notes, the very same notes that he just showed to Ms. Clark during the cross-examination, were turned over to Mr. Darden on July 17, 1995, and he signed for them. And I believe, Your Honor, that at this point in time, what has to be done is this jury has to be told specifically that that was erroneous, that in fact those notes had been turned over on July 17th. No, it's July 17th. Those notes have been turned over on July 17th to Mr. Darden, and that he signed for them, and there is a receipt to prove it. I would ask for that. I would also ask, in addition, Your Honor, that because I think to make that kind of remark in front of the jury is incredibly reckless and is a reckless disregard for the truth when she should know better, that it warrants a monetary sanction as well from the court.
How
And-
much do you suggest?
I suggest $250, Your Honor, which was the last sanction she received. I also suggest a sanction, Your Honor, against Ms. Clark for having blurted out or attempted to blurt out that she was impeaching Professor McDonald with a case after, before direct examination, we set ground rules, Your Honor set ground rules, that she was not allowed to mention any cases at all without first approaching for a sidebar. That warning was reiterated this afternoon, just before I began my, just before I completed my direct examination and Ms. Clark began her cross-examination. And Your Honor affirmed that to her. She knew it darn well, and she ignored it, having been warned twice. And I think that also warrants a sanction, Your Honor, the amount of which I can leave up to the court. But I think,
Well, let me ask you this, Mr. Neufeld. If you recollect when you brought that matter up at the sidebar, and if you recollect, I'm the one who I think invited us over there in the first place, I indicated that I would take that matter under submission, the request for sanctions, once I saw the testimony, saw what it was, and determined how bad a violation it was.
right.
And do you want to expound upon how bad a violation you felt that was and what the damage was to your client as a result of that?
Your Honor, the only point I would make is there was a suggestion, just by bringing up a case and her remark about, well, didn't you testify in this case that? And then she mentioned the name of the case. There was an inference that she was in fact asserting at that point that he was somehow testifying differently here in court than he had been in some other case. Number one, that's not true. Number two, you looked at the transcript, in fact, that she was referring to and saw that one had absolutely nothing to do with the other.
No,
And-
he said the same thing. He said it's tough to see blood on dark fabric is what he said.
Well, that's what I'm suggesting is by her then trying to say to him, isn't it the fact that you said something in this case, she didn't get a chance to actually get out what it was, because that's when you cut her off and asked for a sidebar. But the jury is left with the impression that either it's a more extreme statement or it's a different statement. It's something other than what the witness articulated from the witness stand. That's the whole point of trying to then refer to someone's testimony in another case. Otherwise, it wouldn't be brought up because it wouldn't be impeachment. That's how lawyers get to refer to other cases. The jury by this time is already primed because it's been a technique utilized by lawyers on both sides for impeaching witnesses, that when they hear the person start referring to some other case in your testimony, they believe they're about to hear impeaching contradictory testimony, which they didn't hear here. Granted, it is not the most substantial act of misconduct on the part of the prosecutor in this case. I'm not asking that the court treat it as such, but I do believe that in terms of your own desire to be even-handed and to maintain order here, that if the prosecutor had been warned twice not to do it and did it anyway, that some type of sanction is appropriate. I think, frankly, what she did vis-a-vis the notes is a far more serious matter, because it did, there's no question in my mind that it does immediately and directly prejudice Mr. Simpson, and certainly Mr. Simpson's lawyers, by suggesting that we, by trickery, didn't turn over certain notes that we were required by law to turn over, when in fact they had been turned over.
Ms. Clark?
I've never seen law practiced this way, with lawyers asking for monetary sanctions against the other side. Never. Never. I am dismayed, and I'm embarrassed, and I'm ashamed of my profession when I see it practiced like this. I would never ask for a monetary sanction to be imposed against any member of defense counsel. Not one. That's for the court to do if the court deems it appropriate, but I would never ask for such a thing. And I think Mr. Neufeld should be ashamed of himself. Now, with respect to the discovery violation, Your Honor, I was deceived. The witness referred to notes. I've never seen any notes. I didn't know what he meant. When he said notes, what he actually meant was simply a document that introduced the fact that he had received the evidence at a certain point on a certain date, described what that evidence was, and then 2 pages of diagrams. He called those notes. I didn't know that. When I say notes, I think of written documentation like Dr. Lee made, detailing observations of what he saw. There was no such thing. Now, when he said notes, I was surprised because I did not characterize what he had as notes. When he showed me what he had, I realized that the first page on which he had writing, I had never seen. Never seen. So as far as sanctions go, which goes to good faith or not, I had extremely good faith. I had never seen that before. Nevertheless, I didn't make a big deal about it, quite the contrary. What I did was to minimize it in front of the jury and point out the fact that those quote-unquote notes are nothing more than 2 diagrams and a description of the evidence and the date he received them, and he agreed that that was so. And we further pointed out that those quote-unquote notes made no characterizations of what he saw, did not detail his observations or his conclusions, or any observations that he made of the socks or anything that went on. So it is appropriately before the jury, accurately, exactly what that is. Talk about de minimis, that is very de minimis. Had the witness not characterized something as notes, which I would never have characterized in that manner, that exchange would never have occurred. I was taken by surprise. I had not seen that first page. I don't consider it a big deal now that I see what that first page is, and that is why I didn't ask to approach and ask for sanctions against counsel at that very moment. I could have. I could play the same game they're playing and pick, and every nitpicky little violation, I demand sanctions, and I demand they be put in jail, and I demand they be held in contempt. I don't do that. I don't need to do that. I can just practice law. I can just try my case without playing these little games here about nanny, 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 and neener, neener, and who's got the who's got the last sanction, who's going to pay money this time. This is sickening. You know what we've descended to in this case. That Mr. Neufeld stands before you because the witness characterized something as notes that no one else would so characterize, and because I'm taken by surprise by that, then question him about it because I see something I've never seen before, and stand before you and say that deserves monetary sanction. First of all, those words should never leave his mouth. Second of all, to make the mountain out of the molehill that this is ridiculous. But I was taken by surprise by the witness's characterization. The page I saw I'd never seen before. It has now been accurately assessed in front of the jury, and I don't know what kind of impact the defense would like to have, but I can guarantee this court that I will bring out with questioning from the witness that the 2 diagrams that he referred to I had seen before. And if the court wants me to further inquire of the witness whether or stipulate that that was turned over, that 1 page of document receipt, I've never seen it, but if the court wants me to indicate to the jury in some manner or stipulate that it was turned over on July 17th, I will do so. I don't have any problem with that, but a sanction, I mean, I think that we have really gotten into the outer limits here. With respect to the case that was cited, Your Honor, that case simply cited in support of what the witness was saying. And it was very clear I wasn't impeaching him. Because what my statement was, as I recall it, is that he said, yes, it's difficult to observe blood on dark clothing. And I said, yes, and didn't you so testify in the case of People versus Briggs? Totally consistent with what he said here. It was corroborative. And I wanted to discuss with him the circumstances of that case as by way of analogy. The court has precluded me from doing it so far, but I think it's relevant because he went to some lengths to try and visualize the blood for the jury because of the difficulty they would have in seeing it. And I think that's an important point to make. He didn't do that in this particular case, but it could have been done. In any case, that's all it was. It's corroborative of him, not impeaching of him at all. So what is the damage done there? There is none. I inadvertently forgot to approach, and had I intended to impeach the witness or do something damaging to his credibility with it, I think it would have occurred to me sooner to approach. However, in light of the fact that it was simply corroborative of what he was testifying to, I didn't see this as a harmful thing. And counsel concedes.
Do you recollect being directed on at least 2 occasions that if you were going to refer to a transcript, that before you did so, you were to ask to approach so that I could rule upon whether or not it could be used for that purpose? Do you recollect that?
Yes, I do, Your Honor. I do. And I should have done that, and I simply forgot. And as the court recalls, I did do so on a subsequent occasion with respect to another case. But I forgot. I forgot, this has been a very contentious bit of testimony. There's been a lot to be concerned with, and a lot of argument back and forth about what the witness can testify to and what kind of questioning is going to be permitted. And so I forgot I'm human.
All right, thank you, counsel.
Your Honor.
I'm sorry, hold on a second. Mr. Darden, do you acknowledge that you received a copy of the 3 pages of Professor McDonald's worksheets that were dated April 2nd?
All that I can do is this, Your Honor. Whenever I'm given or provided discovery by the defense, I look at the documents, I count the pages. I don't know that, I don't recall what the notation is on this document.
The judge has the original, meaning, here you go.
It's the 3rd item.
What I see is laboratory worksheets of Herbert McDonald, dated 4/2/95 and 3 pages. When I heard the witness say notes, I do recall having seen the notes. I didn't equate his use of the word notes with lab worksheets. But I count the pages and I look at the documents when I receive them from the defense, and so I certainly received a 3-page document relating to the witness's lab work as they related to the SOC. And I would indicate this as well. Once I receive these documents, I hand those documents to a law clerk. Okay, I don't keep them here in court. I turn them over to a law clerk immediately so that they can be documented as having been received upstairs. They're supposed to be circulated to Ms. Clark and myself. That does not always happen.
I don't know,
So,
Mr.
I don't know.
Darden, if I were a trial lawyer who had the job of cross-examining an expert witness from the other side, I would certainly want to see every note that was ever produced or anything that had been produced by way of discovery.
That's absolutely correct, and I agree with you 100% in that regard.
So
But
doesn't this sound to you mildly implausible?
Well, Judge, if you look at the 3 written on that paper, that I believe I'm the one that wrote that 3. I corrected the 2 pages, so obviously I'm paying close attention to that. But there are 40,000 pages of documents and transcripts and other things in this case. We assume that we get everything. I am often surprised to find additional things, like some stuff I found on Christian Reichardt just Friday. I was amazed to find that. But it'd been up in our upstairs for weeks. It happens. I just don't think that every violation warrants this type of reaction from the defense or a reaction from the court. This is litigation, and these things happen. I've seen Mr. Neufeld approach witnesses on direct with documents he's never shown us. It happens. It just happens.
All right.
Your Honor, just 2 very brief remarks, if I may, please.
2.
Okay. One is, she chose to make it an issue in front of the jury. She could have, at that moment, asked to approach a sidebar and didn't do that. And I think that exacerbates the whole problem.
Well, I have the
And-
transcript of the entire discussion, which goes on for all of 3 lines. It's not a huge discussion.
I understand that, but there was still, the suggestion was made in front of the jury, and it didn't have to happen that way.
That's correct.
And
I agree with you that the assertion that the notes had not been turned over is clear in the record and is incorrect. I agree with you 100%.
Okay. And the second thing, Your Honor, is, look, I agree that perhaps lawyers shouldn't be asking for monetary sanctions, but Ms. Clark's memory is somewhat failing her on this point, because she, on more than one occasion, had sidebars for the volume of my voice was suggesting that the court impose sanctions against me. And, Your Honor, I just feel that perhaps I reacted to her and what she did here because of the suggestions and her request for sanctions against me on earlier occasions. And she's right that it is sad that has to be the situation, but it is in that context that I made that remark, Your Honor. The only other thing I had to say, Your Honor, about the other aspect, which was the referring to the case, I think that the fact that it didn't impeach, and she knew it wouldn't impeach, makes the blurting out of the case all the more inappropriate. Thank you.
Your Honor, may I?
If you must.
Very briefly, this goes to the expert's opinion and the fund of knowledge that he draws on for his expertise. And so prior casework that tends to corroborate or support his opinion is fair grist for the mill in cross-examination of an expert. He
But
has
the
this
problem is,
experience.
I don't care so much about that. I agree there are many things that you can cross-examine an expert about, his or her qualifications being a very broad area. I agree with that. I think you could have more obliquely approached that particular area regarding the difficulty of seeing blood spots on dark materials. That's not the issue. The issue is the court's direction to counsel that before any transcript was to be used, that you were to approach sidebar and ask for direction from the court. That's the problem. What I can't do at this point is, I've apparently used the wrong word search inquiry here, and I keep coming up with the wrong sites to the transcript. I want to review exactly what was said, the context in which it was done. At the very least, tomorrow I'm going to instruct the jurors that the inference that the notes had not been turned over was in fact incorrect, that they had in fact been turned over in a timely manner to the prosecution, and that the jury should disregard any negative inference to Mr. Simpson and his defense counsel. Secondly, I'll take the matter of monetary sanctions or other sanctions under advisement until I've had the opportunity to check the transcript. All right, anything else? Yes. Anything else?
And the grand jury, you want to do that now?
Yes.
Your Honor, for the record, I never asked for Mr. Neufeld to be sanctioned because of the volume of his voice. The court will recall when that occurred.
I think that was my idea.
That's right.
Your Honor.
But in any event, let's not, no, this issue's over. This issue's over unless both of you want to get sanctioned without any recourse to the transcript. All right, grand jury testimony. Mr. Uelmen.
I think we can handle this quite briefly, Your Honor. The defense trial brief dated July 20th with respect to the admissibility of the former testimony of Thano Paradas addressed the question of both the testimony before the preliminary hearing, of which we have a video of his testimony, and the testimony before the grand jury. The authority to use the grand jury testimony comes directly from Section 1291A1 of the Evidence Code. The former testimony exception really creates two exceptions. One, the former testimony is offered against the person who offered it in his own behalf at the prior proceeding, or, subsection 2, the party against whom the testimony is offered had the opportunity to cross-examine at the former proceeding. The first exception does not require that you even have an opportunity to cross-examine, because it is based on the theory that your presentation of the testimony as direct testimony is a substitute for your opportunity to cross-examine. And we cited the Salas case, which is really the leading case interpreting Section 1291. It's an opinion by Justice Bernard Jefferson, who is the author of the bench book on evidence. And in Salas, he was presented with a rather unique situation where the prosecution was offering preliminary hearing testimony that had been offered by the defense at the preliminary hearing. And he noted in the Salas opinion that under subdivision A1, a party's previous direct and redirect examination called by him on the prior occasion is justifiably considered to constitute an adequate substitute for such party's present right to cross-examine the declarant. So we didn't call the witness at the grand jury, the prosecution did. So their presentation of his testimony before the grand jury as direct testimony then justifies use of the 1291A1 exception to now offer that testimony against them.
Mr. Goldberg?
Well, in the Salas case, Your Honor, as I recall, I think the defense called the witness as their own at the preliminary hearing. and the prosecutor then wanted to use the transcript of the trial, and they held that it could, so it's slightly distinguishable, although I don't necessarily disagree with counsel's interpretation of the overall importance of the case or the evidence code per se, although we haven't found any cases that specifically say that grand jury hearings are admissible. Usually we've seen depositions introduced in cases where the declarant is unavailable or preliminary hearings. So while not conceding the issue, only because we don't have any dispositive case law, it doesn't appear that counsel's interpretation of the law that we do have is fundamentally unreasonable. What I would like to draw the court's attention to, however, on the issue of the admissibility of the transcript testimony is that previously the people filed a brief discussing if Thanoparatus were to be called, at the time that we thought that he might be called as a witness, the extent to which his statements concerning the amount of blood in the blood vial would be admissible. As the court will recall, when Greg Matheson was testifying on the same subject to trying to estimate the amount of blood in the blood vial, or that would have been consumed during various transactions, the court required the people to lay an extremely thorough foundation as to how those figures were arrived at. And in fact, he never really was allowed to testify as to approximately what quantities would have been used during certain transactions. The people could only get that testimony in by having him repeat those transactions during the evening, and then the morning following, repeating those transactions, testifying to the actual amount of blood that was used as opposed to an estimation of the amount. So the court has in essence heard that even an expert witness cannot offer estimations as to small quantities of blood that were involved in particular transactions with the blood vial in question in this case. We feel that the same rulings are equally applicable with respect to Mr. Paratus, only even more so, because in fact there is no foundation. There is no foundation for how Mr. Paratus arrived at his estimation, and there is no foundation for how he calculated the amount of blood. In fact, we've talked to him since then, and he said that this was purely an estimate. So applying the same rules that the court applied to Mr. Matheson, that testimony should not be permitted.
Did
Now,
he testify it was approximately 8 milliliters? Is that what he testified?
well,
to?
at first he said approximately 8 milliliters, and then he was asked a clarifying question, what does he mean approximately 8? And he said between 7.9 and 8.1. Now, of course, as Your Honor knows, just by looking at the blood vial itself, it would be humanly impossible to, with that degree of precision, determine the difference between 7.9 and 8.1. So how he came up with those numbers seems to defy common sense when one looks at the fact that this is not a calibrated blood vial.
No, it's marked, my recollection is it's marked on the side of the tube, 10 ml, it's purple top.
The purple top tube is not calibrated.
No, I know it's not calibrated, I'm just saying that the label itself is, they're 5 ml purple tops and they're 10.
This is what's been, I don't know if it actually says 10 mLs on it, but everyone has been under the assumption that this is a 10 milliliter tube, and I believe Mr. Matheson testified to that.
Right.
He said that that was his long-time assumption. In fact, I think the tube actually has a capacity of 12 milliliters. I don't know if that's really all that significant in terms of the court's ruling here. But the point is that there is no adequate foundation and can be no adequate foundation for this kind of testimony. Now, as I'm sure Mr. Uelmen will also agree, because I know that he's researched this part of the law as we have, even if a party did not make those substantive objections at the time of the preliminary hearing or grand jury, we do not waive them and can remake those objections at the time that the testimony is introduced in the form of a transcript. The only objections that are waived are objections that go to the form of the testimony. but not any substantive ones, such as lack of foundation. An objection that something is leading or suggestive would be waived if not raised previously. But all of these substantive objections would remain. So if we could imagine Mr. Paradas testifying in court and being asked how much did you draw, we would object no foundation. That objection would be sustained in light of the court's rulings with regard to Greg Matheson. And I don't think it's an objection that the defense could ever overcome. So that portion of his testimony, if the defense wants to introduce the transcript testimony, should be stricken. And then the remainder read to the jury.
I save the court time on this. I think I can. This is completely misrepresenting and misleading as to what Thana Paradas has already testified to. He's not relying on the test tube, right? He says, I drew 8 cc's. How did you know how much it was? He says, I just looked at the syringe, and it looked to be about 8 cc's. I saw the syringe in his office. The syringe is calibrated by cc's. Okay, that's how one does it. He didn't rely on looking at the test tube after all. He looked at the syringe. That's a sworn testimony at the preliminary hearing. That's a sworn testimony in the grand jury. He is not just an expert, he's a precipient witness. He's simply saying, I drew blood, I looked at the syringe, and it was 8 cc's. Was it exactly 8 cc's? No, it could have been as little as 7.9 or as much as 8.1. It comes in for that. And I would add one other point at this time, Your Honor.
Your Honor, do we have a one-attorney rule here?
Well, Mr. Uelmen was actually addressing the admissibility of grand jury testimony. He then brought up a second issue, which is that none of it should come in, not because it's not grand jury testimony as opposed to preliminary hearing testimony, but because we can't lay a foundation. Since I was the person who was going to put on Mr. Paradas, as you may recall, and the person who had made the motion to strike their testimony.
All right, but I consider this to be a waiver of any other argument on the other issue. All right. Proceed.
Okay. They are suggesting that he has said something to them subsequently in time about his testimony in the preliminary hearing in the grand jury. Number one, when Mr. Goldberg had the argument last week on this issue, he actually suggested there were prior inconsistent statements. We know of no prior inconsistent statements made by Mr. Paradas which would contradict his sworn testimony at the preliminary hearing in the grand jury. More importantly, Your Honor, at this point in time, we have not received a single statement in discovery from the prosecution, a written statement of this witness, an interview with this witness, an audio tape of this witness, a videotape of this witness. We've received absolutely no discovery at all that contradicts what Thana Paradas said in sworn testimony both in the grand jury and at the preliminary hearing.
But here's the problem. They have you, Mr. Paradas is on your witness list, and they have prepared, apparently, to impeach that testimony. Under the rules of discovery, since it's direct impeachment, they may not have to turn that over to you. All right, but...
So he was on their witness list, Your Honor. That's what I'm informed of.
Right.
Initially, they just chose not to call him.
He's on yours now.
Well, I understand, but if they had some statement from him before they rested their case, when he was still on their witness list, we should have received that statement, or it's a discovery violation.
All right, counsel, thank you for another entertaining afternoon.
Sorry.
Your Honor, may I?
No, I've heard enough, guys. Thank you. All right, I'd have previously, and if I haven't formally on the record, made a finding of unavailability of Mr. Paradas. We will allow his prior testimony from the preliminary hearing. Likewise, I believe that 1291 does also allow for the presentation of the grand jury testimony. As to the foundational objection that Mr. Paradas is not competent to testify to the amount of blood that was actually drawn, the court will overrule that objection. Paradas' testimony at the preliminary hearing was that he's been a jail nurse or a registered nurse for 20-odd years, that drawing of blood is a routine thing that he does, and that I assume that there'll be some other foundation later in the record, and I'll allow this testimony subject to that later foundation that calibrated syringes are used for the purposes of drawing the blood, that the purple top tubes are the type that are marked. My recollection of the photograph that I saw, it's marked 10 ml at the bottom of the tube is the type that was used in this particular case, so the objections are overruled. All right. All right, we'll be in recess 9 o'clock.